Estate planning, what every family in Missouri needs to know. Most families think estate planning is something they can deal with later. The problem is, later doesn't always wait. Have you ever heard of a planned emergency? I sure haven't. So, when something happens before you are ready, your family is left dealing with court, confusion, and decisions that they may not have the legal authority to make. In this video, I'm going to walk you through what estate planning actually is, the core documents most Missouri families need, and how to get started if you haven't done any planning ever before. Hi, I'm Nicole Minzy. Here at Minzy Law Firm, we help Missouri families protect their assets, plan for incapacity, and prepare for long-term care so that their plans work in real life, not just on paper. If you want help getting the right plan in place, call us at 636-456-2345. So what actually is estate planning? A lot of people hear the words estate planning and immediately think that it just means deciding who gets their stuff when they die. But estate planning is much, much bigger than that. Estate planning is making sure that the right people can step in, that they can make decisions on your behalf, they could implement different strategies to protect your assets, and they can carry out your wishes if something ever happens to you. This could mean after death, but just as often it means that something happened while you were still alive. What happens if you're in the hospital and you can't speak for yourself? Who pays your bills? Who makes those medical decisions? Who handles things for your family without having to go to court and getting a judge's approval on everything? That is estate planning. And if you have minor children, estate planning means making sure that the right person is in place to raise them if something happens to you and helps them financially at a young age. How many kids would you trust with a large inheritance at the age of 18? Because that's the age the court is going to give them their inheritance, 18. So no, this isn't just about who gets the house. This is about control, it's about protection, and it's about making your life easier for your family during some of the hardest moments that they may ever face. This is something that many people only have to deal with once and twice in their life. Because if you don't create a plan, the state of Missouri has one for you, and that plan is not based on your wishes. It's based on a law that is generic and one size fits all. By the way, we have never created the same plan twice. Every single person's plan has something different. But Missouri's plan is a one size fits all for everyone if you don't put that plan in place for yourself. That means that if you don't have that plan in place, the court will be involved. And the wrong people may end up in charge, and your family will be left dealing with delays, expenses, and unnecessary stress. This is why estate planning is not just a good idea. It's one of the most important things you can do for the people you love. So what are the core documents that most families need? What does an estate plan actually include? For most families, it starts with the basics. First, you need a financial power of attorney. This allows someone you trust to handle the financial and legal matters for you if you cannot act for yourself. That could mean paying bills, handling the bank accounts, dealing with property, or even just something as basic as signing documents. Without it, your family may have to go to court just to get authority to manage basic things. Don't forget, the financial power of attorney is only good for as long as you are alive. The second is the healthcare power of attorney. This names the person who can make those medical decisions for you if you're unable to make them yourselves. A lot of people just assume that their spouse or their adult child can automatically do this. That's not always true. If the authority is not in writing, problems can happen fast. Again, this is only valid while you're alive. Well, there's a little tiny thing if you include the right of sepulture, which is the ability to deal with the body after death. But for the most part, it's only valid while you're alive. Third, HIPAA authorization. This allows the right people the right access to your medical information and the ability to talk to your doctors. Because in a crisis, your family does not just need opinions. They need the information. An interesting point to note that this can be valid for up to 50 years after your death. Makes you wonder why you have to sign one every time you go to the doctor's office. So think about it. Who do you think that document is protecting? Fourth is the Advanced Healthcare Directive. This puts your wishes in writing for end-of-life care and other critical medical decisions. It helps remove the doubt, reduce conflict, and make sure your wishes are followed instead of guessed at. But did you know that in order to be an organ donor, you have to be hooked up to life support in most circumstances? What happens if your Advanced Healthcare Directive states that you don't want to be hooked up to a machine to life support, but your license states you want to be an organ donor? We often refer to these 4 documents as a foundation plan, because if something happens while you're alive, these documents that help your family act immediately instead of getting stuck in court. So then, where do wills, trusts, and non-probate transfers fit in? Now, once you have that foundation in place, the next question is usually this: do I need a will? Do I need a trust? Do I need something else? A will is a document that most people are familiar with. Most people have heard about it. Definitely the most common in the movies. A will says who receives your assets after death, and it allows you to nominate guardians for your minor child. That last part is extremely important. But here's the problem. A will does not avoid probate. A will is actually a probate document. That means that your family still has to go through the court process before anything can be transferred. That process can take months, sometimes even longer. Sometimes it's years. It costs money, a lot of money. It creates delay, and it makes your private affairs part of the public record. Now, for some families, especially smaller estates or situations where everything is going to one person, there's another option other than the will. That's what we call non-probate transfers. Pretty fancy word, right? This includes things like beneficiary designations on accounts, transfer on death, payable on death designations, beneficiary deeds, and properly titled assets. When everything is set up correctly, these assets can pass directly to the intended person without ever having to go through probate after your death, unlike a will. And in the right situation, that can be simple and effective approach. But here's where people sometimes get into trouble. If these designations are missing, outdated, or inconsistent, or there's multiple beneficiaries, or you want control over how the assets are distributed, or you forget to update one, because every asset has its own estate plan and you have to maintain one. That's why we call this approach the do-it-yourself estate planning method. And that's where the approach can start to break down. That's when a trust becomes the better tool. A trust allows assets to be managed during your lifetime, during potential incapacity, and after death without the court involvement that is required with a will, and you only have one estate plan to keep track of. It helps your family avoid probate, maintain privacy, and handle everything in a much more controlled and structured way. And it gives you flexibility. You control who receives the assets, when they receive them, and in some cases can even protect those assets once they're inherited. So the real question isn't whether a will, trust, or non-probate transfers. It's choosing the right structure for your situation, your goals, and your objectives. Sometimes that is a trust. Sometimes that's non-probate transfers. Sometimes it's a will, not often. And sometimes it's a combination of all three. The next thing we often asked is, what does estate planning actually cost? Now, at this point, a lot of people start wondering about the costs, and that is a very fair question. So let's talk about it. Estate planning is not a one-size-fits-all, and neither is the cost. Some plans may only cost a few $100s. Others can cost hundreds. Others can cost thousands. Some cost tens of thousands. But that's not super common unless you have very unique needs, and some people do. It all depends on how your plan is structured and what you are trying to accomplish. The lowest upfront cost is typically relying on those non-probate transfers. Remember, I called it the do-it-yourself estate planning method? This includes things like beneficiary designations, beneficiary deeds, transfer on death designations, payable on death designations. And when everything is set up correctly, those assets pass directly at death without going through probate. That's why the upfront cost is low. You do most, if not all, of the work. But here's the limitation. That only works at death. It does nothing if you are alive but incapacitated, or alive and just don't want to mess with it, like my grandparents were. It does not give any authority for anybody to act for you. It does not coordinate any decisions. It is not a complete estate plan. It's a piece of the plan, and it's a very viable piece for some circumstances, but it's not the whole plan. Now, a will is typically the next step up in terms of upfront costs. Listen, upfront costs. It allows you to direct where assets go and name guardians for minor children. But here's the issue. Again, it only works after death and it must go through probate. That is where the cost shows up. For example, on a $500,000 estate, it is not uncommon to see costs starting around $25,000 to $30,000 once you factor in attorney's fees, costs of the courts, and administration. So while the upfront cost of a will is pretty reasonable, the total cost over time is much, much higher. That's why we jokingly call it an attorney's pension plan. For the attorney, it's a low investment with a very, very high return. And then you have trust. A trust is usually the most expensive upfront cost. After all, you have the attorney that drafts it, and you're paying for the knowledge and expertise that that attorney brings to the table. But in most cases, it ends up being the most cost-effective, the best value overall. Because when it's done correctly, it avoids probate. If you're incapacitated and after death, it reduces delays and disputes. It minimizes those administration and the costs of the court because there isn't any. And it provides structure during both life and death. So instead of paying later through court costs and complications, you're putting the right structure in place from the beginning. And that really is the key point. The cost of an estate plan is not just what you're paying for it today. And that's important to remember. It's what your family has to deal with later. A document is not the same thing as a plan, and the cheapest upfront cost is not always the least expensive overall. What families really need is clarity. They need to understand what each option actually does, when it works, where it falls short, and how it fits into your overall plan. Because once you understand that, you can make the right decision for your family, not just the least expensive one. And estate plans are not all created equally. The good news is getting started is much easier than people typically think. And that's what we get asked. So now I know all this information. How do I get started? You do not need to walk into the office with everything figured out. You just need to start. They say the journey starts with a single step. And a simple first step to take is to just make a list of everything you own. Your home, your bank account, your retirement accounts, life insurance, vehicles, business interests, anything that you have that is of value or is of value to you. Think about your people in your life after that. Who would you trust to handle these different finances if you can't? Who would make the best medical decisions and would follow your wishes? Who do you want to receive these assets? If you have minor children, who do you want to raise them? And who do you want to manage their inheritance? That is enough to begin the conversation. From there, we can help you build the right structure based on your goals, your family, and what you are trying to protect. That's the most important thing. This has to be tailored to you and your situation. And that's what we do. If you don't have an estate plan yet, or if you're not sure if your current estate plan still works, or if you just have some changes you want made, call us at 636-456-2345 to schedule a consultation. We will help you understand your options because that's half the battle. You need to know what the options are, and we'll help you build a plan that actually protects you and your family. And if this video was helpful, like and subscribe for more guidance on estate planning, elder law, and protecting what you have worked so hard to build.